Hi everyone, welcome to our webinar here today. We're doing it on the alternatives to bankruptcy, and the Bankruptcy Act 1966 offers other alternatives that are legally binding but do not have the same effects as bankruptcy. Today we'll probably do a brief outline, introduction of Vincent's, our insolvency division. Then we'll move on to an overview of the bankruptcy process, and then we'll get into the informal arrangements, Part 9 debt agreements, Part 10 personal insolvency agreements, Section 73 proposals, and we'll give you a couple of examples of the Section 73 and the personal insolvency agreements. We probably might just leave the questions to the end of the webinar, so that way we can, if we have time, we can go through some of those questions. Otherwise, we can probably email you a answer to what your queries might be later today. I'm Robert Talbot here at Vincent's, and I've got Stephen Stats here with me as well.
Good afternoon all. So just a quick introduction to the Vincent's Insolvency Division. I'm a registered liquidator here. We have 7 staff members who can take on appointments at Vincent's, and we have offices in Brisbane, Gold Coast, Sydney and Canberra. We offer both personal and corporate insolvency services, and we're always available to discuss any insolvency related matters at no cost to anyone who wants to come in and see us. So whilst we're talking about the alternatives to bankruptcy, I think it's probably useful if we just provide a very quick, brief overview of what the bankruptcy process itself entails, and then we can discuss some of the alternatives and the advantages and disadvantages of those alternatives. So just to start off, bankruptcy is a formal statutory process where a trustee is appointed to the financial affairs of an individual. It can come about by two different ways. It can be that the individual voluntarily declares himself bankrupt, or it may be that an individual, a creditor, brings an application to court to petition for the person's bankruptcy. Bankruptcy generally lasts for a period of at least 3 years. Now there is talk of that changing and reducing the period to 12 months, but those changes haven't been introduced yet, and if it does come in, it's likely to come in probably next year. Now, when a person becomes bankrupt, they're required to file a statement of affairs, which basically just sets out the person's assets and liabilities, and during the bankruptcy period, the trustee will then review what the assets are, review income on an annual basis, and conduct an assessment. And above a certain threshold, the bankrupt would be required to contribute income. The trustee in bankruptcy would also have to perform certain investigations into various financial transactions that may have occurred prior to the bankruptcy, see if there's any transactions that were there to basically defeat creditors or might be voidable in some way. And Rob, do you want to talk about different assets which aren't covered by bankruptcy, just quickly?
Yeah, just quickly, in the bankruptcy, there's certain assets that are fully exempt and some that are partially exempt. There are allowable thresholds in the Bankruptcy Act for motor vehicles and personal effects. Personal effects generally will be an exempt asset, and that can differ depending on whether the personal effects can be considered as excessive. Excessive is pretty objective, so it'll have to take into consideration other factors to determine whether it's considered to be excessive. If it is, then the trustee will probably seek to recover a surplus amount over and above the normal standard, what's considered to be the normal standard of living in relation to personal effects. Motor vehicles, for the first 7,500, I believe, is the exempt portion of the motor vehicles. Anything over that, for argument's sake, if you have a $20,000 motor vehicle, it's worth that, then the first $7,500 is exempt. So the trustee is then entitled to any surplus over that. Generally, mostly a bankrupt will generally want to contribute towards that equity in that vehicle to go towards the estate and creditors. Such things as superannuation is exempt. The trustee will generally look into the past contributions into superannuation to see if there is excess superannuation contributions, in which case they may not then become exempt. But generally, superannuation is exempt.
Also, the family home, if there's, if it's secured to a bank and there's no equity in the house, well then you may not necessarily lose your house in bankruptcy. But overall, I guess there's a stigma associated with bankruptcy, so it also can have an effect on various licenses. So, if you're a real estate agent and become bankrupt, it may have effect on your real estate agent license. So hence why there might be a need to consider alternatives to the bankruptcy process itself. So one of the first alternatives we're going to talk about is an informal arrangement. So it's not it's not covered by the Bankruptcy Act itself. It's really the debtor or someone on behalf of the debtor approaching the debtor's creditors and seeing if a deal can be done with the person's creditors, which will prevent them taking further steps, potentially making them bankrupt to avoid that. Now, obviously, some obvious advantages of coming to an informal arrangement with your creditors would be a cost saving in relation to doing a formal bankruptcy where there would be trustees' fees. But there are a number of disadvantages to an informal arrangement as well. Rob, do you want to just run through some of what you consider the disadvantages of an informal process?
Some of the disadvantages of the informal arrangements is that the agreements are not legally binding, so it doesn't prevent a creditor from initially agreeing to a payment arrangement or whatever proposed arrangement it would be, and then saying, no, I want payment in full, and then goes and makes a court application to make that person bankrupt. So creditors still have the option to take recovery action against the individual. The agreements, by implementing an informal arrangement, it's still considered to be an act of bankruptcy. So by doing that, the creditor can then use that as the basis to get a bankruptcy notice issued on that person to recover their debt. So it gives them a reason then to go ahead and expedite the proceedings.
And you'd have to also get all of the creditors' approval for the process, or I mean, there's no point coming to an informal arrangement with only some of the creditors, because if you don't have to come to an agreement with all the creditors, well then that person would still be leaving them open to the creditor they didn't come to the agreement with, taking bankruptcy proceedings against them. So really it's an all or nothing. You'd have to come to an agreement with all the creditors and then stick to the terms of that agreement. Otherwise, a single creditor could bring the whole process undone.
Yep. The other disadvantage is that although you might have a payment arrangement with your creditors, if you are in a position, or if the debtor's in a position where the debt is so enormous that there's probably no foreseeable possibility of repaying that debt, there's nothing to stop the creditor from accepting a payment arrangement, and then at the end of the payment arrangement, then commencing bankruptcy proceedings against the debtor. So that way you still have a debt at the end of the day, so it may all then end up for no benefit to the debtor.
Now, the first formal process under the Bankruptcy Act, which we'll talk about this afternoon, it's pursuant to Part 10 of the Bankruptcy Act. Sorry, before we talk about Part 10, Rob just quickly pointed out, we're going to talk about Part 9 of the Bankruptcy Act, which is in relation to debt agreements. Debt agreements are binding agreements under Part 9 of the Bankruptcy Act, as I said, between a debtor and their creditors, where creditors agree to accept a sum of money which the debtor can afford. It is initiated with the appointment of a debt administrator, and the completion and preparation of a debt agreement proposal is put forward. There's an explanatory statement which informs the creditors about the person's income, expenses, assets, and liabilities, the personal circumstances, household expenditure, and must give a reason for the financial difficulty. And a statement of affairs is also required to be completed. Once the proposal is put together, it is then lodged with the official receiver, who in turn issues the proposal to all creditors. Creditors would then lodge their claims and then would cast a vote with the official receiver as to whether or not to accept the debt agreement. If creditors accept the proposal, then the agreement would commence. If creditors were not to accept the proposal, then obviously creditors could continue with recovery actions. Now, there are a number of thresholds associated as to who is eligible to contemplate a Part 9 debt agreement. Rob, do you want to just run through some of the thresholds quickly?
Yep, there are three main thresholds. One is unsecured debts that have to be less than $109,036.20, which is indexed in March and September of a year. And you have to have not more than $109,036.20 in unsecured assets. That would include equity available in a house or a vehicle or anything else like that. And the annual income after tax must not be more than $81,777.15.
So basically, Part 9 debt agreements is a streamlined process for individuals facing bankruptcy with a low level of debts. I mean, at the end of the day, debt agreements would provide a return to creditors that would not otherwise be available in bankruptcy, and would avoid the costs that would be associated with bankruptcy, which in itself can be, substantial. It is legally binding. In most cases, contributions to debt agreements can be made from income, and you can trade a business whilst in a debt agreement. However, you would be required to disclose the debt agreement to all people that you were dealing with in the business, and the debtor who does a Part 9 debt agreement can hold a position as a company director or company officer whilst the agreement is in place, and you can retain certain assets unless the terms of the agreement provide otherwise. So what about the situation where the level of creditors is above the threshold, or the level of assets is above the threshold? You definitely, Part 9 debt agreement you wouldn't be eligible for. Another formal alternative under the Bankruptcy Act is what's called a Part 10 debt agreement. Rob, do you want to just quickly run through what a Part 10 is?
Part 10 is a, much like a debt agreement, it's a proposal for an agreement with creditors, which pursuant to the Part 10 of the Bankruptcy Act. It's similar to Section 73 proposals in that there's no restrictions, no thresholds in a PIA, what we call short for Personal Insolvency Agreement. It's initiated by appointing a controlling trustee, and then from the point that you appoint a controlling trustee, the first meeting of creditors is usually held within 5 weeks. I'll probably just skip back a bit there. I'll just go back to the Personal Insolvency Agreement. It's a formal agreement between the debtor and the creditors that sets out how the debtor will satisfy their debts. Now, with the terms, it sets out how the debtor will satisfy their debts. It can be anything the debtor wants. It's pretty much open to whatever terms that they believe that their creditors will accept. There's no restrictions on what the terms can be. It can be a contribution of assets, can be retaining some assets on the basis that contributions are made from income or made from family members, or as you get the picture, it's pretty open.
Or it may be that certain creditors choose not to prove as well, which could increase the return to the remaining creditors that would otherwise be the case.
Yeah, as Steve said, usually in most of these proposals, you can have what we call related or associated parties. That may be immediate family or related family or companies that are associated with that person. And sometimes they can subordinate their claim in the personal insolvency agreement, so that way the return to all the unsecured creditors that are not related is a lot higher than what could be in the past if they were to claim. To initiate the process, the individual usually appoints a registered trustee or a solicitor to act as a controlling trustee. Not that in this day and age too many solicitors do this type of work, but you provide the trustee with the following documents. Usually it's a Section 188 authority, which gives the effect that all the control of their assets of the debtor are actually now vested in the controlling trustee. And the controlling trustee would then have to call a meeting of creditors so that the creditors can consider the personal insolvency agreement that the debtors drafted up.
So just taking a step back, once the person decides to appoint a controlling trustee, the controlling trustee would then notify all creditors of the debtor, and I think they've got 2 business days to do that. And prior to outlining to creditors what the proposal is and providing a report, the controlling trustee would have to basically investigate the proposal and make a recommendation to creditors as to whether it would be in creditors' interest to accept the proposal or not. And as I think Rob said, the controlling trustee must hold a meeting of the creditors of the debtor within 25 business days after the controlling trustee's appointment.
That's generally throughout the year, but if the appointment's made anywhere near to Christmas, it's then extended to 30 days. And they're business days, which means they're excluded.
Now, if this is binding on, if creditors accept the proposal, then it is binding on creditors. They even if a particular creditor didn't agree to it, as long as it's as long as the resolution is passed, and it's a special resolution. Rob, do you want to just outline what that entails?
Yep, the special resolution is a resolution that's passed by creditors where a vote is taken, and for the creditors that are present at the meeting, either by proxy, by power of attorney, or by
Physically
phone
present.
or physically present, it only counts those creditors. So in most cases, not all creditors will turn up, but those creditors, there has to be a majority in number voting for the proposal, and 75% in value being the value of all those debts of the creditors voting for the proposal. So if it meets both the majority number and the 75% in value, then the resolution is considered passed, and the proposal is generally accepted upon that resolution.
And then once the proposal is accepted, the trustee then has 21 days to execute the proposal, and then all parties will then attend to meeting their obligations under the proposal.
Now, just as a general comment on the personal insolvency agreements, although the debtor may have contributed or completed his or her obligations under the personal insolvency agreement. The personal insolvency agreement is not considered to be finalised till all parties, and that would include the trustee distributing a dividend to creditors. So until such point that the final dividend has cleared and the creditors received it all, at that point it's considered to be finalised, although some other parties in the agreement may have already completed their obligations. Just as a passing note.
Now, do we want to talk about the advantages? Maybe we'll leave that to the end. Let's talk about something similar to a Part 10 arrangement, which I know that the topic of discussion today is avoiding bankruptcy. But there's something within the bankruptcy process itself which is very similar to a Part 10, and that's called a Section 73 proposal, Section 73 of the Bankruptcy Act. So once an individual is in bankruptcy, there's also an option to basically get out of bankruptcy and have the bankruptcy annulled, as if the bankruptcy never happened itself. Now, I said it's very similar to a Part 10 in the fact that a bankrupt would put a proposal forward, which the trustee would then lodge with the official receiver within 2 days of receipt, and the trustee would have to prepare a report to creditors, and then would consider and analyse the proposal as put forward under Section 73, would compare the return that's being offered under that proposal to the return in a bankruptcy, and very similar, would issue an opinion on whether creditors should or should not accept the proposal, and then creditors would, at a meeting of creditors, vote to accept or reject the proposal put up under 73. Again, a special resolution would be required from creditors, which Rob said previously is a majority in number and 75% in value. That's of the creditors present at the meeting, so it might be the case that not all creditors decide to attend. And then, assuming that the proposal is accepted by a special resolution, a notice would then be issued to the creditors advising of the acceptance of the proposal, and then at that point in time, the former bankrupt would be given a certificate of annulment, and the debtor would be contractually bound to fulfil the obligations under the composition, but at that point in time, the debtor is out of bankruptcy, and the bankruptcy is as if it never occurred itself.
Yeah, I think it just needs to be clarified that at that point, upon the passing of the resolution, the bankrupt is then given an annulment, which then releases them from bankruptcy. However, they're contractually bound to the composition proposal, and the annulment has the effect of reversing the bankruptcy, so as though the bankruptcy had never happened.
Now, if for whatever reason a Part 10 agreement or an agreement pursuant to Section 73 needs to be varied in any way, Rob, is there an opportunity for the debtor to do that at all?
Yep, there's, as with everyone's life, circumstances change. Sometimes the bankrupt will have a composition proposal that comprises of contributions from their income. In some occasions, some instances, the bankrupt has then either had their work hours restricted or they've lost their job, in which case they're still contractually bound under the proposal. There is an avenue for the bankrupt then to request a variation to the composition, which in a nutshell is that they would request that in writing to the trustee. The trustee would then issue a report proposing the variation to the composition, stipulating the creditors that they'll have until a certain deadline determined by the trustee in notices issued to them to object in writing to a proposed variation. Now, in that report that the trustee issues to creditors, the trustee will then have to do a re-evaluation of the outcomes and the impact that the change has on the composition. In some occasions, sometimes the bankrupt will just request a variation in regards to a lengthier time to make the payments to meet the composition, which that'll be outlined to creditors, and then creditors have an opportunity then to object to it. In the event that no one objects, so the deadline passes, no one objects to it, the variation, the composition automatically takes effect, and then the debtor will then be contributing in accordance with the variation under the composition. If a creditor objects to the variation, then the trustee can consider holding a meeting to either consult all creditors at a meeting, in a meeting environment, or to consider a possible termination of the composition. Now, or you say possible termination. So at that same meeting, again, creditors can vote to either accept it, or maybe they've had time to think about it and they think this is probably the better outcome for them. However, there's some cases there may be a termination of the Section 73. Now, there's a number of ways to have the composition terminated. One is by a court application by the Inspector General, or by the trustee of the composition, or by a creditor of the composition, or by the actual debtor themselves. It can also be done by a trustee when the trustee believes that there is no possibility, or based on circumstances and new evidence and so forth, that the composition can't be fulfilled by the debtor, then the trustee can issue a notice to terminate the composition. And the third one is just by a terminating event in the composition proposal itself, within the terms. And that may be as simple as they've had to contribute 50,000, they've contributed 50,000, the trustee has distributed the money, all the creditors have been paid their portion of the dividend, and it's all finalised. That would be considered a terminating event within the composition.
Now, just whilst I've talked both about Part 10s and Section 73 proposals, well, I guess particularly in relation to Part 10, what are some of the benefits of that as opposed to bankruptcy? Well, I mean, clearly, as we outlined earlier, bankruptcy goes for a period of at least 3 years, whereas if you can get creditors to accept a Part 10 agreement, the debtor gets control over what period the arrangement might go for. It might be that a family member pays an upfront payment, so it's completed straight away, or it might be some sort of repayment plan, which is for a shorter period than 2 years. The agreement itself might outline whether the trustee has the ability to recover antecedent transactions. So we were talking before about, if large payments have been made to a superannuation fund, a trustee in bankruptcy might be able to recover that. Well, a Part 10 agreement could say, well, those type of recovery actions may not be available. Whilst the controlling trustee is appointed, someone looking to do a Part 10 can't act as a director of a company, but once the Part 10 is fully completed, well, then that person can obviously again become a director, which would be a lot quicker than potentially under the 3-year bankruptcy period. Rob, do you want to talk about some more of the advantages?
Of the Part 10s?
Yeah.
Yeah, the Part 10s have been, the advantage of the Part 10s is the time that it takes to, because it's subject to statutory deadlines, the meeting has to happen at a certain time, then the meeting happens, the creditors vote, and then it comes down to what the terms are of the personal insolvency agreement. So the turnaround, if it was a lump sum upfront payment and was made prior to the acceptance, then the turnaround could be quite quick on the basis that creditors accept it. And then, as at the turnaround there, if you have a client or you are a person of a company and you want to hold that directorship, it may mean that you step down for a short period, and because of the PIA's quick turnaround period, you may be able to then pick it up again after the agreement's been completed. And again, if it's an upfront payment, then once the trustees distributed a dividend, it then will finalise that, and they can move on their merry way.
And one thing we didn't mention earlier, but Rob, do you want to explain what happens? Is just say that a debtor is putting forward a Part 10, but creditors, for whatever reason, choose not to accept it at the meeting of creditors. What's the outcome then for that? Is it automatic bankruptcy?
No, at the meeting of creditors, there will be a resolution passed generally by creditors if they don't accept the proposal, requesting that, well, compelling the debtor to present their debtor's petition, so they enter bankruptcy voluntarily. However, that's not enforceable. Although it's a resolution by creditors, it's not enforceable, so it can't force the debtor to go and do it. However, by presenting the PIA, it's an act of bankruptcy again. So then the creditor can use that as the basis to go on bankruptcy if they choose to. You can't propose another personal insolvency agreement for at least another 6 months. So you're pretty much stuck with a rock and a hard spot.
But as you said, it's not automatic bankruptcy if they don't accept it.
No.
A creditor would still have to take action and force the bankruptcy. Now, we did mention 73s. As I said, it's not. It is a requirement to go into bankruptcy first, but it is similar to Part 10 in a number of ways. And I guess practically speaking, if a person has been bankrupt for a couple of years, you can propose Section 73 at any time within your bankruptcy. So I mean, I've known some bankrupts wait until the very end of their bankruptcy and then put forward a 73 proposal. Now, I guess one difference between a 73 and a Part 10 is that if the debtor has been in bankruptcy for a period of time already, and the trustee in bankruptcy has conducted all of their investigations and made income assessments, and there's no return to creditors, I guess with the period of time that has passed, a lot of angst is taken out of the situation, and it may be that creditors are prepared to accept something rather than nothing, or accept less than they otherwise would have if the debtor had just been proposing a Part 10 right from the get-go. Would you agree with that?
Yeah, I agree with Steve that once they're in bankruptcy, it's the end of the line. And for creditors, commercially, you're either looking at no return whatsoever, in which case you'd have to write the debt off. But if they were going to offer a Section 73 proposal with some money, I suppose it becomes a commercial decision for the creditor, as if do they want some return compared to no return. It becomes a commercial decision. Whereas if you're doing a PIA, there's still another step to declare you bankrupt. If a creditor believes that you have further assets that they believe can be recovered by the trustee, they may want to take those proceedings against you to declare you bankrupt because of that. Whether you do or not could be another thing. Whereas in the 73, I don't think that becomes an issue because there's no facing any, if it doesn't go through, you don't really face any possible bankruptcy because you're already there.
Now, I guess we also should point out that it's by doing a Part 10, it is still going to have effect on your credit record, and it will show on your credit record, and after your agreement's been affected, it's going to be on there for 5 years. That's right, isn't it, Rob?
Yeah.
Yeah.
So they'll be there for a number of years after. In a 73, Section 73, you'll be presented with a annulment, which some bankrupts have used to repair their credit rating through various agents, utilising that because it's reversing that whole bankruptcy, no matter if it's like 2.5 years down the line.
Yeah. But in saying that, I guess a person who's got mounting financial liabilities and might have a number of credit cards outstanding. I mean, if the mere fact that they're not, meeting those obligations and every month they're defaulting, I mean, in most situations their credit ratings is really not good to start with. So a Part 10 may not necessarily have a huge impact, which it might otherwise do. And by doing a Part 10, you might actually be circumventing having a long history of not paying bills on time. So in some sense, it whilst it does go on the record, perhaps the record may have been blemished to some extent anyway. So it doesn't have as big as a detrimental effect as you otherwise might think. It might be useful to go through a couple of examples of what actually has been proposed under Part 10s and 73s. Rob, do you want to run through a couple of examples?
Yeah, I've got an example here for a Section 73 composition. We'll just quickly go through some of the facts there. Mr. Smith was made bankrupt on the 14th of August 2015. He has creditors totalling about $750,000. He's employed as labourer at $55,000 a year. Now, he doesn't have any, the trustees done their investigations because it's been some months since they've been appointed to date. There's no real property, there's no investments, there's no shares, there's no money owed to him. He's just the average Aussie Australian with a mounting debt. He wanted to put forward a proposal, a Section 73 composition proposal, with an upfront payment of $10,000, which came from his parents. The important thing here is to remember that in most 73s, the contributions to the composition generally should come from a third-party funder, either a family or a relative, or from an asset that's not divisible in bankruptcy. So it can come from their income, but if their income's below the thresholds, that would be fine. Generally in a Section 73, you wouldn't be able to include any assets that are generally already vested in the bankruptcy trustee, which would already be available to creditors. So it would have to be something extra. In this case, the trustee did not identify an antecedent transaction, so there's no transactions prior to bankruptcy, transfers of property, avoidable transactions that the trustee could recover. And they determined earlier in the bankruptcy that there would be no return to creditors. Mr. Smith was also, they assessed Mr. Smith annually on his income at $55,000 as labourer. There's no foreseeability that it would increase. So they did the assessment, and his is $55,000 gross. And the threshold, so once you take all the taxes and so forth off, he falls below the threshold to be liable to make contributions to the estate. So the return would be, he wouldn't be liable, so there's no return from that avenue. The trustee would normally, in this kind of case, recommend that the composition be accepted on the basis that the return to creditors is greater than if the bankruptcy was to continue. And that wouldn't be just the sole reason. In a lot of instances, it's other factors as well. It'll potentially be the certainty of, say, whoever's making the payments for the composition. But generally here you can see with the dividend, after taking trustees' costs of $3,000 for calling the meeting and doing the 73, the dividend was 0.093 cents in a dollar. So just less than 1 cent in a dollar. Then it comes down to commercial decision with creditors that, is 0.93 cents in a dollar better than 1 cent are better than nothing. That could be a typical case. It doesn't have to be as much, but the trustee does make their recommendation. They do make the comparisons between bankruptcy and the 73 composition. Sometimes when it's in the 1 cent, there has to be some kind of certainty provided so that by recommending it to creditors, they're certain if they're going to accept such a low dividend or return, then there's some surety that that will actually occur and the composition will be completed.
I guess with any of these proposals, there's no guarantee that creditors will accept it. At the end of the day, it's creditors' decision as to what they're prepared to accept. But I guess in this instance, the creditors knew in bankruptcy the guy was already bankrupt. The trustee had already done all these investigations, and there was simply not going to be a return. So at the end of the day, they creditors in this instance were happy to accept something rather than nothing.
Yeah, with the composition, people are going to be reminded that there are some instances where they don't get accepted, and if in those instances, it may be the cost of the trustee calling the meeting. Now, with the trustee's costs, when the trustee receives a request to propose a Section 73 on behalf of a bankrupt, the trustee also has the right to refuse to call the meeting of creditors if there's no adequate provision in the composition, or there's no agreement made with the trustee on the fees incurred during bankruptcy up to the date that they're wanting to propose the 73, and the costs for calling a meeting, and there's another set of costs for the actual trustee of the composition. So it's probably a good thing if your client also meets with the trustee when they want to do a Section 73 to see if it's viable.
I'm just conscious of the time. Rob, we might have time just for maybe one quick example of a Part 10. Do you want to, which example?
Okay, we have a Part 10 PIA. So I should have here. So Mr. Doe wanted to initiate the Part 10 process by appointing a controlling trustee on the 18th of May 2015. The meeting of creditors was held on the 22nd of June 2015, and the meeting was adjourned for 7 days to the 30th of June, where creditors just wanted further queries answered by the trustee. The PIA was accepted on that day, on the 30th of June. Subsequently, the PIA was executed by both the trustee and the debtor on the 6th of July 2015. Mr. Doe's creditors totaled about $6 million, and this was all a result of personal guarantees that he provided for Associated Energy's debts. He was putting forward a Part 10 proposal, which consisted of him paying $40,000 in addition to the $7,000 that was already previously paid to the trustee to form part of the funds for the PIA, and that all his divisible property was excluded from the personal insolvency. So all his assets weren't going to be included in the PIA. He was going to retain them himself. Mr. Doe was a structural engineer, and he advised that he was due to start a job on the 15th of June 2015 in the UK, and the trustee received some documentation confirming that his income was about 130,000 AUD. The trustee then made an assessment of his income for the next 3 years on the basis that he'd be earning 130,000, and assessed that he would have to be contributing probably a total amount of 57,522 over the 3-year period. Mr. Doe wanted to avoid bankruptcy on the proviso, on the basis that he would, being a structural engineer, his professional body and licensing would require him to forfeit his license. And if he forfeited his license, obviously he couldn't he couldn't continue with the employment over in the UK, so he'd have to find alternative employment. Without his licensing, it's estimated that his income would be about 50,000 gross each year for the next coming 3 years if he was to go bankrupt. So that way the return in the bankruptcy in that scenario on 50,000 would be zero. The trustee determined that the estimated return under bankruptcy would be between 0 and 2.4 cents on the dollar. The trustee also determined that the estimated return under a personal insolvency agreement scenario would be between 0.47 cents and 2.6 cents in the dollar. Although those numbers are quite low, it's only because the debts are like $6 million. It's not because they're not getting a good return. So the trustee recommended to creditors that they accept the PIA on the basis that the return was greater under the PIA than it was under the bankruptcy. The PIA has greater certainty for creditors because the money would be paid up front right now. Whether he finds employment of 50 grand a year for the next 3 years in bankruptcy, there is a risk that he may not, or he may be employed for some period. So that creates some certainty there. The debtor was compliant and there was no committed offences. The risks of the benefits under the PIA were a lot lower than under bankruptcy, and ultimately would avoid the costs of a bankrupt state, associated with bankrupt state. So the final dividend was distributed on the 14th of October 2015 at a rate of 45.26 cents on a dollar. The PIA was finalised on the 29th of October 2015. That was more to demonstrate the quick turnaround for a personal insolvency agreement, and shows how you can possibly avoid losing a certification for a profession by doing it that way. I think we come to the end.
And that's the end of our presentation.